Welcome to rePROs Fight Back, a podcast where we explore all things reproductive health, rights, and justice. I'm your host, Jenny Wetter, and I'll be helping you stay informed around issues like birth control, abortion, sex education, and LGBTQ issues, and much, much more. Giving you the tools you need to take action and fight back. Okay, let's dive in. Hi, rePROs. How's everybody doing? Things here are going well, and I hope they're well where you are. It's to the time of year where I can finally have my windows open most of the time. It's a little later than I would like because I have seasonal allergies, so I can't have them open too early in the spring or my allergies get really terrible, even on medication. So they're not too bad right now. So I'm able to have my windows open all the time. And I'm not the only one who's excited. My cats are in the window like almost all the time. And they're so happy when they can do that. So this week's episode is a little heavier than usual. So I figured we would do a nice, light and fluffy kind of check-in. So I think I might have told you all about this before, but I'm not 100% certain. So forgive me if I'm repeating myself a little bit. But so right before everybody got locked at home, it was my birthday. And I had been thinking about like making a change and doing something fun for my 40th birthday. And I was thinking, it might be kind of fun to dye my hair pink. And I wasn't really going to do it. It's one of those things like, oh, I should do it. It'd be fun, but just never really I make it happen. But the craziest thing happened when I got to my hair appointment. My hairstylist was like, okay, so I had this wild idea on my way in today. I was thinking, what if we dyed your hair pink? And that was totally a sign, right? Clearly, I had to do this. So for my 40th birthday, we bleached out all the red and dyed my hair pastel pink. And it's been so much fun. Well, so I don't know if any of you have done like pastel colors, but they fade pretty fast. So I have been having to do like the leave-in, the coloring conditioners. So I've been having so much fun while I have been at home doing colors that I probably wouldn't normally do, like going to work. So I've had a really fun fuchsia. I've done rose gold, which I have loved. And I'm getting ready to do an aqua, which I think is going to be so much fun. I don't know that I would have ever dyed my hair blue normally, but I'm having fun being able to play with it while I'm at home. And so everybody gets to enjoy it on Zoom calls instead of in person. The other thing that I did was I needed a couple things from Sephora. So I went on and was looking at looking at lipsticks, and I decided, there's all these funky colors that I have looked at so many times and have really wanted to buy, but I'm like convinced they would not look good on me. And I said, you know what? Screw it. If there is ever a time to get all these funky colors that I don't know that I can pull off, but to do, it seems like now is that time. So I got several colors. They were on sale, so I didn't even feel that bad about it. And I got like a metallic green, a periwinkle blue, a like really dark purple that's like almost black. I am having so much fun putting on these funky lipsticks for Zoom calls. Not all of them are super flattering. That's okay. I'm cool with that. It's been something that has added a little bit of pizzazz and fun to my day. And, sometimes you just need to put on a bold pop of color and have fun. So that's where my brain has been at the last couple weeks. And so right now my hair is getting back to almost blonde. The last color I did has faded out. So I'm trying to decide maybe by next week's episode, I think I'm going to do the fuchsia again. I think I have like enough of that left to do it one more time. So I probably do the fuchsia again, and then I will be turning to the blue. So that's where my hair is at right now. I know you've all been wondering. So with that, we're going to make a hard turn because this week's episode is kind of a heavy topic. We're going to be talking about the finalized rule changes to Title IX that Betsy DeVos proposed and have just been finalized. They will be taking effect in August. And so that means this episode is focused on sexual harassment and sexual assault. We don't do a lot of talk about sexual harassment and sexual assault. It's mostly focused on policy. But, just make sure that you are in a headspace where you can listen to it. And if not, you can come back later. Or if you need to skip this episode altogether, totally understandable. But, since we are talking about sexual harassment and sexual assault, it's really important to make sure that I'm not just putting that information out there, but we're also giving out resources. So if you need someone to talk to about sexual harassment or sexual assault, please reach out to RAINN. You can find them online at RAINN, RAINN.org, or you can call them at 1-800-656-HOPE, and they will connect you with someone in the area who is with a sexual assault service provider. Okay, with that, we are going to talk to Shiwali Patel with the National Women's Law Center about these proposed changes to Title IX and what they are going to mean to survivors. Hi, Shiwali. Thank you so much for being here today.
Thank you for having me back to talk about the Title IX rules.
Yeah, no, I learned so much last time, so I'm really excited to have this conversation again. But in case people didn't listen last time, let's start at the beginning and talk about what is Title IX.
So Title IX is a very, very critical anti-discrimination law. It protects students and employees from discrimination in educational programs and activities. And, typically, I think when people hear Title IX, they're assuming that it has to do with athletics, but it's actually much more broad than that. It does prohibit discrimination in sports, but it also covers discrimination in recruitment or admissions, financial aid, course offerings, facilities, extracurricular activities, in addition to school sports, employment, and also school climate, which includes sexual harassment and other forms of gender-based harassment. Title IX also prohibits retaliation against someone for kind of speaking up about sex discrimination that's happening in the school. And so retaliation can include suspension or expulsion, reductions in grades, or additional harassment, and more.
Great. So who is protected under Title IX?
So Title IX protects all students and employees in schools, regardless of gender. Title IX is about discrimination based on sex, which includes pregnancy and related conditions. It also includes sex stereotyping and sexual orientation and gender identity. And something that I think is really kind of ironic in a way is that we are approaching the anniversary of Title IX. Title IX was passed June 23rd, 1972. And I say that it's ironic because, the anniversary is coming up at a time when the Department of Education is weakening Title IX protections. And, and so organizations like ours, for example, which I'll talk about later, are really will be fighting to preserve those protections.
So we're going to be focusing on the sexual assault rules that the administration promulgated recently, but maybe we should talk a little bit about kind of what the landscape looks like right now at schools so that people kind of have an idea of why the rules are so important.
Yeah, these rules are critical because they ensure that schools respond to sexual harassment, including sexual assault against students and employees. And it's so critical because of how widespread sexual harassment in schools is. There was a recent survey from the American Association of Universities that came out last year that found approximately 1 in 4 undergraduate women in college are sexually assaulted. This is higher from an earlier survey that they conducted where it found the rate was 1 in 5 undergraduate women. And for students who are in middle school and high school, K-12 students, nearly half of them are subjected to sexual harassment or assault. So it's a very, very high number of students who are impacted by sexual harassment. And it's even greater for students with marginalized identities. So, for example, there was a study in 2018 that found that more than half of LGBTQ students were sexually harassed at school during the past year. And for college, there was one study that found that nearly 1 in 4 transgender and gender nonconforming students were sexually assaulted. And for students with disabilities, there's a study that showed that they're 2.9 times more likely than their peers to be sexually assaulted. And so, the numbers are devastating. It's particularly, it's harmful for all students, and especially students who, have different marginalized identities. And not only that, when schools are not responding effectively to harassment, the impact is quite significant. We know, and from the cases that we litigate, that too many individuals who experience it are often dropping out of school because they don't feel safe on campus. Some students are even expelled because of the lower grades that they've received in the wake of the trauma. Some of them are even punished by their schools after reporting sexual harassment. And we've seen that in the cases that we litigate where students in K-12, there are a few cases actually that are high school students who, after reporting to their schools that they were sexually harassed or assaulted, were either disciplined in one case, but a student was disciplined and punished for it. In another case, a student was kind of put into some substandard alternate program. And so, the schools were not responding effectively and their education suffered as a result. And we know this is particularly bad for students of color, especially Black girls who, because of race-based and gender-based stereotypes, too often are disbelieved or sometimes are blamed for being sexually harassed or are punished for it. And so, our concern is that these issues that we're seeing impacting survivors will just be exacerbated by these rules.
Yeah. And the numbers are always astonishing. Whenever we talk, my mind is always blown. Like 1 in 4 students is unreal. And what was it? 1 in 2 in K through 12?
Yeah, it's nearly half of students are, before they graduate high school, are sexually harassed. So there was one study that found it's about 56% of girls and 40% of boys. And so it's very common. And too often schools are not responding appropriately. So, in the cases that we litigate, that's what we've seen, where, their students were met with disbelief or even punishment when they reported their harassment, and it didn't just end and it would get worse. And so that's why it's so important that Title IX exists, because it is a civil rights law and it requires that schools respond to the sexual harassment because that's what students are entitled to. That's their civil right. That students and employees are, when they report, that their complaints are taken seriously and that their access to school is not harmed by the sexual harassment.
So with all that as background, in comes the Trump administration and proposes this new rule. Do we want to give a little bit of background on that before we get into the actual rule itself?
Yeah. So this rule is terrible. It would essentially require schools to take steps that will discourage students from reporting sexual assault and other forms of sexual harassment. And when you review the rule in its entirety, the rule itself is quite lengthy. And then when you include the preamble, which is like the Department of Education's justifications for their changes, it's about, at least in like the published version of the rule, over 500 pages. So it's very long. But when you review it, it's pretty clear that through these changes that the Department of Education is trying to make it harder for students to report and to get help for sexual harassment, and that the department is mandating a process, these hearings and procedures that would be unfair to complainants and intimidating and could be re-traumatizing, like requiring direct live cross-examination. they're really just turning Title IX on its head. And it's apparently motivated by sex stereotypes and this myth that survivors, especially women and girls, tend to lie or exaggerate about sexual assault and other forms of harassment. And by this perception that sexual harassment has just such a relatively trivial impact on those who experience it, right? So there's like a minimization of the harm and the impact on students and employees. And, we see that these rules are particularly harmful for students of color, pregnant parenting students, LGBTQ students, and students with disabilities, as they're more likely to experience sexual harassment and also more likely to be ignored, punished, and pushed out of school entirely. And, this is just the latest piece of DeVos's undoing of civil rights protections for survivors in school. It started in 2017, in the beginning of the Trump administration, when DeVos rescinded critical guidance from 2011 and 2014 that outlined what schools must do to respond to sexual harassment. And what she did is she replaced it with new guidance that was confusing and harmful and removed protections for students. And just weeks before she did that, DeVos made statements that kind of diminished the full range of sexual harassment that deprives students of equal access to educational programs. She claimed that, and I quote, if everything is harassment, then nothing is. And then there was this other official who oversaw the department's Office for Civil Rights at the time, Candace Jackson. She was a Trump official. And she reinforced the myth of false accusations to the New York Times in an article. And she claimed that 90% of her office's Title IX investigations were really the result of drunken sexual encounters and regret. And then you've heard the president himself has repeatedly publicly dismissed and disputed allegations of sex-based harassment and violence made by women. And what's really telling is that these officials have not expressed the same skepticism of the denials made by men and boys accused of sexual harassment, including sexual assault. So then, about a year later, after the 2017 guidance came into effect and DeVos rescinded the 2011-14 guidance, the department submitted their proposed Title IX rule in the fall of 2018. And there were so many comments. There were almost 125,000 comments filed, the majority of which opposed the rules. And so it wasn't just survivor advocates or women's groups or civil rights advocates, but there were associations of colleges and universities, school superintendents, principals, mental health professionals, teachers, members of Congress, students that opposed the rule. So there was a lot of opposition. And so, the final rule eventually dropped a little over 2 weeks ago. And as I said earlier, it's lengthy because there were so many comments. The Department of Education is required to address those comments. So there are a lot of pages in the preamble where they do that. But ultimately, if these rules are allowed to take effect, the new Title IX rule would make schools more dangerous for all students. It would require schools to ignore many reports of sexual harassment. It'll require schools to use procedures that treat victims unfairly and make it harder for students who have experienced sexual assault to come forward. And it would give religious schools a license to discriminate on the basis of sex without notice to students. And so, this is why the National Women's Law Center is actually going to be, we've announced that we plan to sue the Department of Education on these rules. And I think last week, the ACLU had filed a lawsuit as well, challenging these rules.
That's so great that you all are fighting back. So, because it is a 500-page rule and there is so much to get into, we're just going to kind of divide it up into areas of harm. And so you've touched on a lot of them already, but we'll talk a little deeper about what exactly the rule allows. So the first bucket you talked about is that the rule would allow schools to ignore victims.
Yes. So, the Department of Education has explicitly stated that its goal in issuing this rule is to reduce the number of sexual harassment investigations conducted by schools. And this rule would accomplish that because it would make it harder for students to get help for sexual harassment. And in fact, what's quite perverse is that it would make it harder for children in schools to get help for sexual harassment than adults in the workplace. So it would accomplish this in a few ways. So schools would be required to dismiss all reports of sexual harassment that occurs in a study abroad program or that occurs outside of the school program or activity. So this includes most off-campus and online sexual harassment, even if the sexual assault survivor must take a class taught by or shared with their assailant. Schools must dismiss harassment of complaints when students are just assaulted in the wrong place. And we know that, the trauma from having experienced sexual violence is not dependent on the location of the assault, right? So the impact on the student's education will not be dependent on whether or not the assault occurred off campus or on campus. And these rules just ignore the harm and the impact on the student's education from having been assaulted. The rules would also require schools to ignore reports of in-school sexual harassment when the student has not yet been, quote, effectively denied equal access to a school program or activity. So what that means is that a lot of survivors will be forced to endure repeated and escalating levels of abuse before their complaint can be investigated. So rather than allowing schools to respond to all complaints of sexual harassment when they know about it, this rule would require survivors to first claim that their access to education has suffered as a result of the harassment before their school can investigate. And in higher education, schools will be empowered to ignore any harassment that is not reported to a small set of high-ranking school employees. The colleges and universities will not be required to take any action if a student asks an advisor, coach, or professor to help address sexual harassment. So under this rule, Michigan State would have had no responsibility to stop Larry Nassar when his victims reported abuse to athletic trainers and coaches. And for the first time, students will only be able to file a sexual harassment complaint with the school while they're still only if they're participating in or attempting to participate in a school program activity when they file the complaint. So that means that a school is not allowed to investigate a complaint of sexual harassment, even if the respondent, so even if the perpetrator is still enrolled at the school or teaching at the school. If the survivor has already graduated, transferred, or even dropped out because of the harassment, and she does, or he or they don't want to re-enroll or stay involved in alumni programs. So similarly, if you were a visiting high school student, you're sexually assaulted by a college assistant or professor during an admit weekend, and then as a result, decide not to attend that university, then the student would not be able to file a complaint with that college because they're not planning to enroll there. So this would tie the hands of schools that want to respond to known sexual harassment, particularly by individuals who are affiliated with the school and who could be a serial rapist or abuser. And there's more. There's just so many terrible things about this rule, but also for the first time, schools would be allowed to dismiss complaints even during a pending investigation or hearing because the respondent, so the perpetrator, is no longer enrolled in or employed by their school. So that means if a student graduates or transfers to another school after they sexually assaulted another student, the school will no longer have to investigate the complaint. Similarly, if a teacher retires or resigns after their sexual abuse of many students over several years comes to light, the school will no longer have to investigate or determine the scope of the abuse, the impact of the abuse on students, and even whether other employees knew about the abuse but ignored it, so that the school could then take measures to ensure that that doesn't happen again. So without an investigation, the school wouldn't be able to remedy the hostile environment for the survivors and possibly the broader school community or take steps to prevent that type of abuse happening again.
So, as if the bucket of ignoring victims wasn't enough, they're also allowed to mistreat victims.
Yes, and to have procedures that are quite hostile So, this rule would require schools to use procedures in investigating and resolving sexual harassment complaints that hold sexual harassment complaints to a much higher, more burdensome standard than complaints of other types of student or staff misconduct, ultimately making it harder for students who've experienced it to come forward. So, for example, schools will be required to frame investigations around the presumption that no sexual harassment occurred. That is, schools will be effectively required to presume that all students who report sexual harassment are lying. And this presumption only applies for sexual harassment, but not other types of misconduct or harassment. Some schools will be required to use a more demanding standard of proof for determining responsibility for sexual harassment than they do for other types of student misconduct, even though there is no evidence that students who report sexual assault are less credible than those who report physical assault or other types of harassment. And this rule, like all of them, really rely on and perpetuates this false and toxic stereotypes that women and girls tend to lie about sexual harassment and assault and are just less credible when they're bringing these complaints forward. And another piece that has received a lot of attention because it is quite significant, like the others, and also very concerning, is that in higher ed, survivors and their witnesses will be required to submit to cross-examination that is direct, oral, and in real time by the respondent's advisor of choice. So this could be anyone from an angry parent to a fraternity brother or a criminal defense attorney. But it's important to know that schools are not courtrooms. In school proceedings, students typically don't have counsel. They don't have legal protections that are provided in the courtroom. They don't have rules of evidence. There isn't trial procedure or meaningful protection from inappropriate, irrelevant, or victim-blaming questions. And sexual harassment is already so underreported. About 12% of sexual assaults in college are reported, and survivors already face many barriers to reporting, including fears about their complaints not being treated seriously or that they'll be blamed for the assault or punished if they report. And so requiring schools to have a process like this that would allow for something that could be so re-traumatizing, like direct live cross-examination, would deter many students from participating in investigations at all. And the Department of Education does not have to require institutions to allow for direct live cross-examination. In fact, in the rule, in the preamble to the rule, the Department of Ed acknowledges that these grievance procedures that they're prescribing through the Title IX rules are not required under due process. So it's not like students have a right under due process to be able to engage in direct oral and live cross-examination. And yet the department is still moving forward to require schools to have this incredibly, burdensome procedure that could only be re-traumatizing and deter students from coming forward with their reports of sexual harassment. And so, any rule like this that requires colleges and universities to conduct live quasi-criminal trials with live cross-examination, when no such requirement exists for addressing any other form of misconduct at schools, really communicates the message that survivors are uniquely unreliable. And implicit in such a requirement is this deep-rooted skepticism of sexual assault itself.
Yeah, this whole process really seems to meet the goal of what they were saying of having less incidents of sexual assault reported. Not happening, reported.
Right, exactly. And it's already so underreported. And, it really just turns Title IX on its head, because the purpose of Title IX is to ensure that sex discrimination is not the end of anyone's education. And that's why there are requirements under Title IX for schools to respond to sexual harassment. Because when students are sexually harassed, including sexually assaulted, and the school is not responding appropriately, many school students are then just pushed out of school altogether, and so their education suffers. However, this rule would just require and allow schools to do less when they should be doing more, given how prevalent these incidents are in schools and how much they impact students and their ability to feel safe and to learn. So another thing that's also very troubling about these rules is that it prohibits schools from providing the evidentiary rules and protections that make cross-examination work in courtroom proceedings. So, for example, if a survivor refuses or is unable to answer even a single cross-examination question, perhaps because it's too traumatizing, then the school will be required to disregard all of the survivor's statements in the formal complaint, at the live hearing, and in all other written or oral evidence, even statements in a video of the incident that clearly indicates that the survivor said no.
That is wild.
Yeah, it's so wild, and it's going to make it so hard for schools to be able to investigate and to find out what really happened. And it's such a broad exclusion of evidence. And so similarly, if there or a nurse or any other witness who is unavailable for cross-examination at the school, even if it's for a very good reason why they're not available, none of their previous written or oral statements in their police report or medical record or text or an email message can be considered as evidence by the school. So schools will also be prohibited from excluding any cross-examination question or evidence that is overly prejudicial or misleading, or that relates to the survivor's dating or romantic history with other people, so long as it does not explicitly refer to their sexual history with other people. So that means that the school would have to be able to consider those types of they have to allow those types of cross-examination questions in.
Wow.
So it's very, very, very troubling. And, again, it's just going to make it harder for schools to be able to thoroughly investigate a complaint of sexual harassment assault. And it's such a broad prohibition on evidence. And it's quite astonishing. It's like the department is making it harder for schools to do what they need to do, which is to investigate and find out what happened when someone comes forward with a complaint of sexual assault.
Again, it's the more I find out about this, the worse it gets.
Yeah, and it's what's also, frustrating for someone who's, trying to understand these rules and read them is that, as I mentioned earlier, there are several hundred pages of preamble. This detail about cross-examination and statements that were not made through cross-examination, this is in the preamble to the rule, which is like buried in hundreds of pages of explanation and justification, clarification from the Department of Education on the rules. This isn't even in the rule itself. So, I can't imagine that for students who are trying to now understand what their rights are if they've been sexually harassed, to be able to really understand what these Title IX rules mean and how they would impact them, because they would have to read this preamble. There's hundreds of pages to fully to get information about how these rules would affect them, because it's not all in the rule itself.
And, there was another bucket of ways that there's a harmful response from school, and that was having mediation. Do you maybe want to explain a little bit about why that is problematic?
From guidance dating back to 2001 by the Department of Education, schools were prohibited from using mediation to resolve sexual assault complaints. And they should be, because mediation assumes both parties share responsibility for the assault, and it can allow assailants to pressure survivors into inappropriate resolutions. And because mediation often requires direct interaction between the assailant and the survivor, which can be re-traumatizing. So under this new rule, schools would be allowed to use mediation to resolve any complaint of student-on-student sexual harassment, which includes sexual assault, domestic violence, dating violence, and stuff. And we're not the only organization, the only ones who have concerns about this. There have been students, survivors, and advocates who have opposed this rule, this allowance of mediation for sexual assault, because it can foster coercion, it could allow abusers to manipulate victims, and it could allow students to be pressured by administrators to enter into mediation, rather than, their complaint of sexual assault being being investigated through the approval process.
And I think there was one last bucket that really seemed worth digging into, and that was religious exemptions.
Yes. So ultimately, what this rule would do is give religious schools a license to discriminate on the basis of sex without prior notice to the Department of Education or students. So religious schools would be able to discriminate against students without notifying the Department of Education in advance that they intend to do that. So under Title IX, there is an exemption for religious institutions to the extent that compliance with certain provisions, not all of Title IX, but with certain provisions of Title IX, conflict with their religious tenets. And so this Title IX rule would allow schools to just claim a religious exemption without any prior notice. So that means students or their families wouldn't know if the institution that they are planning to attend would be able to or would claim that they have a license to discriminate against them because of, for example, their sexual orientation or their gender identity, or because they are, access birth control or abortion as a student. These religious institutions under this Title IX rule would only need to claim a religious exemption after they are already under investigation for violating Title IX. So this means after a student is discriminated against and they file a complaint with OCR, with the Department of Education's Office for Civil Rights, then that religious institution that has discriminated against that student based on their sex can then claim that they are actually exempt from Title IX and therefore allowed to discriminate, rather than announcing before this discrimination happened that of their intent to be able to discriminate based on sex, if that makes sense. And then there was a separate proposed Title IX rule that was published in January 2020 that would allow many more schools to claim a religious right to discriminate simply because they subscribe to, quote, moral beliefs or practices. And so these two rules, separately and together, will be especially dangerous for women and girls, for LGBTQ students, for pregnant and parenting students, and for students who access or attempt to access birth control or abortion.
So with all of these parts of the rule, what would this mean for people if it went into effect?
Something that we've been hearing about from survivors and organizations that work directly with survivors is that there will be less reporting, that there is a lot of concern about the rule in its entirety, but in particular, some of the provisions that would be hostile towards survivors if they report like direct live cross-examination. And so we anticipate that there will be fewer reports of sexual assault and sexual harassment because students will not want to be subjected to these hostile procedures. And also because their schools would not be able to investigate a lot of their complaints of sexual harassment if it occurred outside of an education program activity or if it didn't meet this really narrow definition of sexual harassment that the Department of Education now requires. And this is very concerning because about 12% of sexual assaults on campuses are reported. That's very, very few of the actual incidents that are reported. And so what schools should be doing is to ensure that survivors actually feel safe enough to report. If not for, an investigation to be initiated, to be able to receive some sort of supportive measures from the schools or accommodations so that they can continue to learn, like academic accommodations, extensions on exams, counseling, other types of health services. And the Department of Education should be requiring that schools do more to ensure that, there are safe spaces for students to get the help that they need if they are sexually harassed, including sexually assaulted. But these rules would actually exacerbate the issue of underreporting of sexual violence. What this also means is that generally, this will be viewed as the federal government. This is actually, this would mean that fewer students would feel supported from the federal government, that they're not going to see the Department of Education as an avenue for help because the Department of Education as a federal agency is the agency that administratively enforces Title IX. So that means they are a place for anyone who claims that they've been discriminated against by their institution, where their civil rights have been violated, they can file a complaint with the Department of Education to initiate an investigation, and for the Department of Education to then get their school into compliance to remedy the harm. But now with these hostile and rules that really weaken protections under Title IX, the Department of Education will not be the avenue for many students who have been mistreated by their institutions to be able to remedy the harm that they've experienced. And because of this, because these rules are so arbitrary and they turn Title IX on its head and they weaken Title IX into ensuring that all students are protected from sex discrimination, including sexual harassment, we at the National Women's Law Center are ready and planning to sue the Department of Education to hopefully to stop these rules from going into effect.
Yeah, so it's definitely worth mentioning that the rules are final but not in effect yet. So what can listeners do right now? What actions can listeners take to try and fight back?
I think what's really important for listeners and for anyone to do is to speak out about these rules and how they're harmful, and to make sure that the narrative about the rules focuses on how students will be harmed and how the rules would create unfair procedures that would harm survivors of sexual violence. And to really counter this false narrative that's perpetuated by DeVos and many men's rights advocates and sexist extremists who falsely claim that these rules would protect due process rights or that they would ensure that grievance procedures are fair, when the rules would actually do the opposite. The department itself has acknowledged that due process does not require the procedures that they're putting forward through the Title IX rule. And, the Department of Education is putting forward rules that would create special rights for named harassers at the expense of complainants. So it's important that their narrative, that their false narrative is not kind of controlling the view of how these rules are perceived. That, as many people as possible kind of speaks about the harm that will impact students, and in particular survivors of sexual assault.
So one thing I've been doing while we are stuck at home and working from home is trying to have something fun at the end. So what is bringing you joy right now? Doesn't have to be work related, can be something really small.
I think so. I have two kids. I have a toddler and a baby, and having more time with them, it does bring me joy. As tiring as it can be to balance that with work, it does bring me a lot of joy to be able to witness their lives more and how they're growing and how they're experiencing the world. And as hard as it is right now, it does bring me joy to be able to spend more time with them.
That's so great. Let's see. I think that is everything. And Shiwali, thank you so much for doing this. I really appreciate you being on the podcast again.
Yeah, thank you so much for having me. And, I can go on and on about these rules because they're terrible. So much to them.
How is it always like, I know how terrible they are. I know they're terrible. But every time I talk to you, they're always so much worse than I think. It's so wrong.
I think they're so wrong, right? When you actually hear about all the ways, there's so many ways that they would just make it harder for students to get help when they're sexually harassed. And it's wrong that they are framing this as their attempt to provide greater civil rights protections. I mean, it just feels like gaslighting because it's not doing that. It's rolling back protections. Well,
thank you again.
Thank you.
Thanks everyone for listening. I hope you made it through this heavy episode. It was a great conversation about really horrible things and terrible changes that have been proposed. Like I mentioned in the episode, I'm always shocked every time I talk to Shiwali about this because I feel like I know how horrible it is. And yet every time I talk to her, it's worse than I thought it was. So, it's really important that we raise our voices to make sure that people are aware about these really horrible changes that are going to be happening. With that, feel free to reach out to us if you have any questions or comments, or if you have episodes or topics you would like us to talk about, feel free to shoot me an email. It's at jenny@reprosfightback.com. You can always reach out to us on social media. We're at rePROs Fight Back on Facebook and Twitter, and rePROs FB on Instagram. And with that, we will see you all in 2 weeks. I hope everybody has a great start to their summer and everybody stay safe. Thanks. For more information, including show notes from this episode and previous episodes, please visit us at our website at reprosfightback.com. You can also find us on Facebook and Twitter at rePROs Fight Back and on Instagram at rePROs FB. If you like our show, please help others find it by sharing it with your friends, and please rate and review us on Apple Podcasts. Thanks for listening.